Ask a Pro episode 5 with Thomas Christopher. He is an estate planning attorney and somebody who's been in that business for quite a while. So we're excited to have you on Ask a Pro, Thomas.
Well, thanks for having me here today. It's a pleasure to be here, and I know a ton of people have a lot of questions about estate planning, so happy to do that.
Well, thanks. So welcome everybody who's going to be here attending. I see that we have 4 people on already. More will be joining as we usually that's what happens. More will join as we kind of start very shortly, I should say. This is recorded and we will have it available on our podcast and other social media platforms. And just real quickly, some of our best practices kind of suggestions. If you have a question for myself or for Thomas, just put that into the Q&A. And try to keep them out of the chat, but please do feel free to put in any questions that you might have as we go into this. There's going to be a short presentation. I'm going to try to wait on the questions and then till after we're done. So we will get to them if you put them in the Q&A, and you can find the Q&A down there too. Also, welcome and thank you for listening for anybody or who's watching or listening to this after the recording. So with that, I would like to turn the presentation over to Thomas.
All right, very good. Well, again, thanks for having me here today. I'm happy to do this. I've been doing this my whole career, a little over 28 years. So all I do is estate planning and trust administration. So that's just a little bit of a background. Let's see here. All right, let's see if we can get things moving. So this is my talk today is part of a ongoing discussion that I have called Essential Estate Planning in California. And this is the most recent version of that, the 2022 version as of right now. So David, I don't know if you wanted to highlight the issues.
One of the things that's really important is with any attorney, as they're discussing, topics in general, that it is not legal advice. So I put this in here and I wanted to kind of read it. So for those of you who are not watching and maybe listening to this, like the contents of this presentation and all of its graphics are intended as educational materials to convey general information only. This is not legal advice. Individuals should seek their own legal advice before making any decisions.
All right. So the biggest thing is everybody has their own sets of facts and circumstances. And with estate planning, what you're dealing with are how the current state of the laws and how they interact with your set of circumstances. So that's why this is general. So the good news, the state of California does not yet have its own estate tax system. So when we're talking about estate taxes and things, what we're talking about is the United States estate tax, which is also known as the death tax. Okay, and it's based on everything that you own or a person owns at the time of death. Okay, there are certain rules and thresholds that people reach for estate taxes. Right now, the threshold to have a taxable estate is 12.06 million per individual. So for married couples, it's 24.12 million. Most people do not have estate tax situations. They may if a lot of people have inherited property down the line and things like that, and that's what it is, but most people don't. Annual gifts can be given to individuals up to $16,000 without having to file any kind of a gift tax return or having what's called a taxable gift, okay? This current law is only temporary. It's going to be in place until about 2025, and at the end of 2025, it's going to revert back to kind of the 2015-ish time period. It's going to be somewhere between 5 and 6 million. 5.49 is what the suggested amount is. Not 5.5, but 5.49. So you'll go down from over 24 million to somewhere between 10 to 12 million for married couples, 5 to 6 million for individuals. Okay. They may change it prior to it lapsing. Who knows? Assets passing to a spouse, community property assets and things like that are exempt. You have to be really careful as to whether you're dealing with United States citizens or people who are non-citizens, whether they're permanent resident aliens or what have you, depending upon their status. You just have to have proper terms in your trusts if you have different citizenship issues. Okay.
And that TC is going to, I think it's going to come down to when later on in the presentation when you talk about wills, trust, and intestate and test.
Right.
Please say that.
Intestate.
Intested, which means no will or trust or anything.
Exactly.
And having having again something recorded if you are a resident alien or don't have or are not a citizen,
Yeah.
a U.S. citizen, there's going to be things need to be done to kind of protect your interests.
Correct. And you can still have a trust. You can have, I quite often have spouses where you have one citizen and one non-citizen. They can still have trusts. You just need to make sure that the proper provisions are in your trust documents to deal with those circumstances. Okay. You really need to plan your estate because it's not a common sense situation. And if you want your assets to go to the people you want them to go to, you've got to have a real, just direct and straightforward plan. With that, I do want to talk about some of the documents that we interact with quite frequently. First, just about everybody has heard about a will. They hear about the reading of the will in dramatic circumstances and things. Those things don't happen here in California. Typically, they don't happen anymore. They may in other states and everything, but wills are just a legal document that says how you're going to distribute property after you pass away. Wills have to be approved by a court. A probate process is what it's called. So the probate court governs the validation and distribution of the will. So you need to file a petition here in California that's called a probate petition. You need to, the court will appoint a person to manage that estate, typically the executor. That's what people have heard of. They'll say who receives the property. Those are the beneficiaries of the estate and things. So wills have to go through probate process. The issue here, yes, go ahead.
Is that done before, let's say I write down my will and
Yes.
I need to have it signed, I need to have it notarized, but then do
Right.
I have it go to the probate to have a probate petition done before my passing or after my passing?
No, this is after you've passed.
Gotcha.
Because wills can be revoked at any time. So
Right.
they can be changed, updated, things like that. So you don't lodge a will with the court or file a probate petition until after somebody has passed.
Gotcha. Thank you.
Okay. Now, probate, this is what we're talking about. People get confused about the need for trust documents because they confuse the threshold for a taxable estate, millions and millions of dollars, with the actual threshold for probate. The threshold for probate is if you own real property in California, or if you have assets that exceed $166,250. It's a random number. They increased it from 150,000 to that because inflation or what have you, but that's the number.
If you own real property in the state of California, odds are you have an estate more than that.
Right. And real property is treated specially because it's always been so historically. So if you own real property, even if it's it's the vacant land in California City that somebody purchased 10 years ago because it was going to make them,
right,
with some big investment plan. You really need to have the trust to avoid the probate process. The issue is this: if the lens that we look at in planning people's estate is to avoid cost and time and formality, going to probate checks all three of those boxes. It's costly. You have to hire an attorney to file the probate petition, and they get paid statutory fees. They get paid special fees for dealing with real property and other things that they do. It's formal because it makes what you're having under the purview of the court, and it becomes public record also. Okay, time consuming, especially through the COVID periods and things like that. They've closed down outlying courts. So you have a probate court in downtown Los Angeles, and you have one out in Lancaster, in this area where we're coming from. And what we're dealing with is understaffed situations and an overrun system. So where it used to take 1 to 2 years, now it's 2 to 3 years. You can get a hearing within about 3 to 6 months, But then once they appoint who the executor is going to be and issue what are called letters, giving them powers, they'll say, great, come back in about a year and a half. And if you don't file proper documents like the court's requirements for accounting and things like that, every time they kick you at least another 6 months. So staying out of the probate process and out of the courts is the goal for doing that.
And you can
Okay.
stay out of the probate process if you at minimum have a will.
Well, no, wills go through probate.
Okay.
So
it will go through that process.
yes, if you have a will, you end up in probate. Okay.
Which means if mom or dad or who I'm a beneficiary of a person's estate.
Yes.
And they had nothing.
Right.
Let's say I'm the only familial survivor. I'm the direct descendant. I am now going to be in the probate courts. Let's say it's a $500,000 estate, and that $500,000 now goes into probate, and then it's going to be 3 years or more. If I don't hire an attorney, I decide I'm smarty pants enough to be able to do it myself. I make a mistake on my court documents, I'm kicked back another 6 months. So not only do I have a 3-year period, but then there's all of those fees that are going to be charged at a stated rate. So in theory, my $500,000 estate could be reduced by tens of thousands of dollars.
That's correct. So the issue is, and that's if mom owns a modest home and maybe has a bank account. It doesn't matter how simple it is. And we're assuming that you don't have disputes. Okay. So if you have siblings that are going to, dispute because they don't like each other, and you took something they wanted when you were 12 or something like that, that causes problems. Okay. Now, trusts. The majority of trusts that people have are what are called revocable living trusts. Okay. They're prepared while somebody is alive and they can be changed. Okay. It's a legal arrangement where the creator of the document, they can be called the settlor, the grantor, the trustor. The author of that document gives control of its property to a trust. The trustee is the manager or administrator of the trust. So for me, I form a trust. I can be the creator. I can be the manager. And then if I can't manage, I name other people as successor trustees to manage. Okay. Or if I don't want to, if I want to have like a personal business manager or something like that. So that's, and they manage for the benefit of the beneficiary. So you have settlor, trustee, and beneficiary. While I'm alive and competent, everything is for me. There's no limitation on my spending all of my assets and bouncing the check to the undertaker. Okay. So the idea is, I name successor beneficiaries or alternate beneficiaries for when I pass. Okay. So again, it's an agreement that says who's going to manage, what they're going to manage, and who's going to receive it. Okay. And if you think of the trust like a box, I'm making kind of a box shape here.
I can see it.
You'll want to put your stuff into the box because only properly funded trusts are valid. You can have a trust, and I have people that have come into my office very frequently. They have a trust, but they never transferred any of the property into the trust. So they ended up having to file probate documents because they had an empty box. Okay. So
they're in that probate court 3 years and a bunch of fees that they have no control over.
And during that period, you still have to pay all the property taxes. You still have to pay the mortgage. You still have to pay all of these things. Okay. Because properties can go into foreclosure and everything during those periods. Okay. Now, we talked about a living trust again, created while you're alive. It can be updated if it's revocable. There are things called irrevocable trusts that are typically created for specific tax reasons. Okay. So, and we're not going to get into that today because it's rather detailed, but living trusts that probably 98% of the trusts that people hear of are what are called revocable living trusts. Okay. Now, being intestate or intestate, I call it intestate, means you have nothing. Okay. You didn't prepare a will. You didn't prepare a trust. The space rock fell out of the sky and took you out. You're done. Okay. You end up in probate court. So it's just like if you have a will, you end up in probate. So There are rules, there are laws in California called the Probate Code, and they govern wills and trusts and all of that. Well, they have a pecking order of your kinship. So it's your parents and you and your siblings, and then your kids and aunts and uncles, and then nieces and nephews and aunts and uncles on out. So they're called the rules of consanguinity, or the rules of the bloodline. So if you don't get along with your siblings, and you haven't prepared anything, they're the people who get everything you have under the law. Okay. If you have children, it'll go to your children. If you have a spouse, should go to your spouse. But sometimes people don't title things and they don't hold them in jointly. There's all kinds of reasons that people do that. So having nothing is the worst way to go. You end up in probate, and there are, again, a lot of other questions to be answered.
And then this is where a lot of people can contest, put up arguments, and just really delay the thing for who knows how many years.
Correct. So, all right, trust planning advantages. Avoiding probate for all of your assets transferred to the trust. Now, it doesn't mean that you title everything to the trust. It may mean that, you name your spouse as your primary beneficiary, or your kids as your primary beneficiary, and then you name the trust as a contingent beneficiary to certain types of assets, financial assets that you hold. Not everything is just titled to the trust. So it's avoiding probate for everything. That's the main reason. It keeps your estate information from becoming public record. Whatever you file in probate becomes public record. Federal estate taxes can be avoided. Okay. You can also deal with, create the best situation possible for your children or child or whomever to receive your property, and not have them reassessed for property tax purposes, which to a lot of people, that's the most realistic thing that can cause trouble for them. Having a house that was owned by your parents reassessed can destroy the value. And you just have to be careful as to how you deal with those things. The supporting documents that are prepared with the trust can help avoid conservatorships. If you become incapacitated, you're alive and unable to manage things. Some of the supporting documents we prepare are called power of attorney documents, and those are for financial decisions and generally healthcare decisions. So those can help avoid having to go to the court to have somebody appointed for that. Those conservatorship proceedings are as expensive and time consuming and problematic as going to probate. So we want to, we don't want to invite the courts in to our private situations. What we want to do is make sure that we have a plan that clearly states what people want to have happen when they pass, that clearly states whom they want to manage things, and give those people the ability to appoint other people. Because if people move away, pass away, or you don't like them anymore, you've got to update them. It's because some people are unable or unwilling to be your trustees if you've named them. And quite often people don't talk to people about that. So
you mean when they don't talk about it, I mean, let's say I was named as the trustee for an estate, and they just put me down in their trust document and didn't tell me.
Right. And then you may not want to, or you may have moved away already, or it's something of that nature.
Gotcha.
So, power of attorney documents, again, there are two types. These are used while a person is alive and unable to manage their affairs, or if they need assistance in managing their affairs. So you can have these documents effective either immediately upon signing or upon someone's incapacity. If it's only upon someone's incapacity, then after you receive, at least in my experience, 2 to 3 letters from a doctor that says they can't manage their affairs, then you can step in. But with elderly parents and things who still have their capacity, but they just want you to assist, like being a bookkeeper or some kind of a business manager for them and dealing with certain transactions, having things effective upon incapacity may be a concern. You may want to consider having those effective immediately upon signing if you're someone who writes the bills for your parents or conducts business transactions for them and things like that. So when these documents become effective is determines how useful they can be under certain circumstances. Again, the two types that we have, one is a durable power of attorney for finances. The other is called an advanced healthcare directive. The durable power of attorney for finances, again, allows you to step into somebody's shoes and engage in financial transactions. You should be careful. There are all different types. If you want to download a 2-page check the box, fill in the blank document off the internet and fill that out, it may not be as effective if you have a long-term incapacity as having a detailed document prepared. People have all kinds, there are all kinds of different forms and they get them from all kinds of different places. And if you're contemplating doing business, dealing with a financial institution or a bank, they have requirements. They want things done their way. And if your documents don't give somebody expressly a power to develop on land or deal with things like that, they may say, just go to the court and get permission. Like, that's an easy thing to do. Again, you end up back in court. So that's important. So financial power of attorney documents are very important. And who you name to be your agent is very important. Things change, people move away again. They may not be the people that you want, or after people pass, you need to name additional people. The advanced healthcare directive is for healthcare decisions. They can be, again, effective temporarily or long-term. And it's everything from, who's going to make those decisions and what decisions you're allowing them to make, to, do you want to be buried or cremated? Let people know that, because that whole industry is a racket if people don't know what you want, little things like that. So it's just very important, if you're going to have a trust and you're going to prepare these documents, that you also have the supporting documents that would make things a lot easier if you're alive and can't manage things.
Right. And I have personal experience with that because my mother had Alzheimer's and she passed away from it. She had it for 7 years. And there was a period of time where I think that she could have been able to sign something away before the doctor said that she's really not able to, she should not be able to sign any sort of document because she's lost the capacity to understand what the ramification of that signing would do.
Sure.
But it's something where when she was very, when she was initially diagnosed, she had Alzheimer's. It could have been something where you sit down and have this directive, because my sister and brother and I went round and round, like, okay, mom would have liked to have been buried in a pine box.
Right.
Well, in the state of Oregon where she was, we were not going to go through that process of trying to have her buried in a pine box. Then there was a new thing that one of my siblings looked at, where it's like it's some sort of liquefaction of the body, and then you kind of let it go into some other place. It's like a form of cremation, but it's not with heat.
Yeah.
And so ultimately, we wrestled back and forth, and it got pretty heated on some of the conversations, because my sibling who was advocating or wanting to know, they dove into it like, why wouldn't you want to do this? And I'm like, right. Stop talking to me about it. We already know. So,
right. It's hard, and you everybody has a different impression as to what mom or dad or whomever wanted. Yeah. So I always specify that in just a very basic thing. And once everything is put together, it should be in a binder where everything is in one place. The binders we use have a provision for memorial instructions. So if somebody did pre-plan for burial or cremation, we make sure that paperwork is there. So that's important. Those are kind of papers that at time of need, people can't often find.
No, I understand. Let's show the last slide. Sure. Because I want to kind of bring that up. So for anybody who is looking to maybe reach out to Thomas, his email address is there. Also, mine is there as well too. So if you will have any questions, just about anything, what kind of vinyl fencing are you putting up on your ADU project, David? I'll tell you. So with that, if you could stop share, and then we're going to dive into some of the questions that we have.
There we go.
Thank you very much. Okay. Leslie Miller. Hi, Leslie. She and I go back years. She's a fantastic real estate agent and is now in the Napa Valley. So her question is, can you tell me if it's possible to get a loan on a fee simple real property that is entitled in the name of a trust. Specifically, will lenders make a loan on such a property? If so, can you tell her the names of the lending companies?
Well, they will. Different companies have different procedures. Some people want to take the property out of the trust to do business with you because they don't like interacting with business entities. Okay, the legal entity is the trust. It's kind of like owning a business, right? They don't like dealing with legal entities. They want to deal with you as an individual. Others have no problem with that. You just have to document the trust exists. One of the documents you receive, aside from the trust itself, is typically what's called a certification of trust. It's a declaration by the trustees of the trust that clips all the kind of legal requirements that people want to hear. I'm the trustee. Here's the name of the trust. Here's when the trust was created. Here's when it was restated or amended. Here are the successor trustees, and here are the powers of the trustee. Sometimes they have their own documents that they want you to sign. Banks and financial institutions have their legal departments that have their own requirements. So they can. If you'd like to email me, I'm happy to provide the names of people that I know that do it. I don't get any benefit from referring you to people other than knowing that they may be able to help you. So
thank you very much for that. Next question is from Roger. Has the probate court typically challenged holistic handwritten wills?
No, they're called holographic. Okay, so a holographic will. So it can be the Howard Hughes stereotypical cocktail napkin will, or the will number 5 or 6 or 7, those kind of things, to you just writing on a piece of paper what you want. They still allow them, and they can be filed. The issue with that is you have to prove that you have to have someone familiar with the person's handwriting, if it's actually written in their handwriting, that can testify that it would have that's their handwriting. Sometimes you hire experts, question document examiners to prove whether or not that's more likely than not that's the person's handwriting, because of the tilt of the line and how they made their A's and the little all these question document things. So so they still allow them. Holographic wills are still allowed, but again, as a will, it has to go through the probate system.
So you're tied up for years and years and tens of thousands of dollars.
Correct.
That was a really good question. Thank you for that one. This is another question. This is a question from Roger. If we create a living trust, does that trust need to file a tax return each and every year, or only upon death of the creator?
That is a great question. So here's the deal. The trust remains revocable while the people who prepared it are alive. Okay. The tax ID number is typically your social security number. You do not file separate tax returns for it. Okay. Now, depending upon if a married couple, they have certain options to deal with certain types of plans to engage in tax planning. And there are certain types of plan where once one of the spouses passes, the assets divide into 2 trusts. It's typically called an A-B trust. What it is typically you have a decedent's or a marital share, and you have a survivor's share. Okay. Sometimes with blended families, they use those so that on the death of the first spouse, 1/2 of the assets become irrevocable, or 1/2 of the trust becomes irrevocable, cannot be changed. It actually gets its own tax ID number at that point. Then you would have to start filing tax returns
after it
for
splits, after the person
Correct.
passes, and then
right. And it's largely an accounting process. You determine what the assets are and what should be divided between them and things like that. And you build rules into the trust as to what the surviving spouse can use, which assets they can use during their lifetimes and things.
It is a great question, because when you said blended, I mean that how many people get divorced in the United States and then get remarried, and then you have these wonderful unions, and sometimes you don't have wonderful unions, but then having the specifics of how that person wants to have everything passed on, I think, is critical.
Exactly. And it's and even if you don't have that, on the death of the surviving settlor, okay, so say you have a married couple, they were married for, 60 years, whatever, one passed away, then the survivor passed away, then the trust becomes irrevocable, okay? Once both spouses have passed, no one else can change it. It gets its own tax ID number at that point, and then you would file a trust tax return. I always recommend, even when you don't have a taxable estate, that people who have trusts or their successor trustees consider filing a trust tax return, even if it says this is not a taxable estate, because that shows the IRS or the franchise tax board that you've filed the return. It starts the time period running for them to come back and go after, the trustee. Because if they have back taxes and things that weren't taken care of, and the trustee distributes all the assets, they're looking for the responsible person. So that dutiful child who went through all that trouble ends up having people come after him, he or she, for distributing the property. So,
and that's not something you would really ask, because you're sharing that, and what's popping into my head is like, okay, am I going to go for my dad's tax returns? Am I going to start diving in there to see if he filed all of his taxes? To make sure.
Most accountants can look and ask the IRS if there are any tax returns that are
Right.
due or any back taxes and things, so that you do that when you're filing the final tax return for the person, the final personal tax return.
Mhm.
And then you would be able to see that. So that when you have a trust, the order of distribution is, a person passes away. There's actually in the probate code a 40-day period. I call it a cooling off period, before people can file a probate petition or engage in transactions, quite often, especially with the court. And that's really for the final creditors, the final medical expenses or people like that, to get their bills in, or the notice of their claims. So once that's done, you have obligations of the estate that are taken care of first, or expenses. And then once those are taken care of, you can start making distributions. Okay. So you got to take care of the obligations, debts, obligation, expenses, any tax issues first, and then you make distributions. So people who are, mom passed away, we got the house on the market in 2 weeks, we sold the house because the market was bananas. All of a sudden, we're distributing the assets, and then a year later, you get a supplemental property tax bill, right, for $3,000, $4,000, $5,000, and the trustee's going, "Hey, brother and sister, let's give me back some of that money." And they're like, "We spent it. We don't have any money. I don't have any money for you. Good luck with that."
Oh, so that would be kind of crazy. Roger had a follow-up question. So he says, so if a populated, if I'm not sure if I'm saying that right.
If I populate a revocable trust, so if I create one with dividend paying stocks, then that trust does not need to file
on its own.
You do not, while the trust is revocable and you are alive. That the trust assets are those dividend paying stocks, and the interest you receive go through your personal tax return.
Thank you for that. So Patrick, I see your two questions. Why don't we get to those, and then Leslie, I'll get to your follow-up. So I'm not sure if you can see it, Christopher, but he says, can you specify transactions that are yet to be executed in the future in a living trust? For an example, an SB9 lot split of a private property, real property. Can the trust have if or then conditions such as if SB9 lot split occurs, then new lot goes to son X? So I'm guessing that, Patrick, you're asking, if you split it, one is going to go to son A or child A, and then the split lot goes to child B.
Right. Yeah, you can do that. Okay. You can deal with, you can specify what would happen with, say your grandparent has a trust that you're receiving ongoing payments from, and that gives you a power to appoint those assets to people. It can be whether it's property related and everything. The issue is when you build in the powers of the trustee, which people typically call the boilerplate, in a document. I call it a trustee's toolbox. And it's a minimum probably 10 to 11 pages in my documents. And the first 10 or 11 pages of the durable power of attorney mirror those powers. Because, for the financial decision makers in a trust or under the durable power of attorney, they're typically the same people to avoid conflicts. And you want those powers, you want the same people with the same powers making the same decision. So whether it's a lot split, whether it's a business and who's running the business, you have 3 children and child number 2 was the one who, got in there with Pop and did the work and brought, made the business successful. Well, once Pop passes away, everybody comes back and they're like, here we go.
Right.
How is that business going to be run and dealt with when the one child was the only one who was actually working it? All those kind of things are the things that are make up, I call sitcoms and soap operas, with regard to the story of people's assets and how they deal with them.
Well, I also think to add on that is that you really don't think of it. You think that everybody knows. Let's say, I'm the parent. I'm working the business with my child, and everybody around us knows that we're the team. But then when I pass, everybody may come up and say, okay, well, let's just sell the business, and I want my cut, my equal cut.
Right.
So if I were to be, if I'm looking at this going, hey, we built this business together, you need to have X percentage. That's why it's critical to be able to identify that so that there's no infighting.
Right. And that's the same whether it's the business or the duplex or the income property or the whatever. You have certain other decisions to make with regard to the properties you're receiving, because now that Proposition 19 had recently passed, it affects the distribution of assets between parents and children and requires that things be reassessed for property tax purposes. So you've got serious issues with regard to the value of property and rents and things like that if these long-term owned properties are reassessed.
Yeah. Patrick has another question, which says, what kind of situations would warrant both a will and a living trust? It seems that it would be simpler and cheaper to just have a well-written living trust to protect the assets and to avoid probate court.
So, when you have a trust, you actually always have a will, but it's a special type of will that goes with the trust called a pour over will, P-O-U-R, like a pitcher of water. Its job is to act as a safety net for the trust. And it only becomes effective in one instance. Well, there may be a couple of them, but the main instance is this. Say you had an IRA and you named your spouse as the beneficiary, and you didn't name contingent or alternate beneficiaries. You both passed away. The IRA was worth $205,000, and you didn't have a named beneficiary. That's an example of an asset that would exceed the probate threshold, and you haven't designated a beneficiary, and it wasn't titled to your trust. So it would normally have to go through probate. The pour over will, the pour over provision says, for all of my assets, I give the property, all of my assets in my estate that are outside of my trust, I give the property to the trustee of my trust to be distributed according to the terms of the trust. So it's the lifeline that makes sure that whatever assets you have, even if you left them outside of the trust, the plan that you prepared will apply. Now, if you have proper supporting documents like a detailed schedule of assets that lists real property with the assessor's parcel number, just the names of the institutions where you have accounts, and you have language in there that is conducive to, hey, whatever we own should be considered part of our trust. Okay. There's also a document called a general assignment that people typically view as a throwaway document. It's a one-page document that's notarized that says, we hereby assign all right, title, and interest to all our property, including without limitation all of our real property, to our trust. And we list the real property in the same way, address with assessor's parcel number. If I can show that it was your intent that that was an asset of the trust, I can file a petition with the court, and within about 6 to 12 weeks have an order from the court telling the county recorder's office to transfer that asset to me as the trustee of the trust, because there's a petition process where you can do that called a UCASTAT or a HEGSTAT petition. That is, I know it's getting into a little more detail than we want, but if you have the proper supporting document showing the indication that it was your intent, and but for some mistake or inadvertence you didn't do that, you can get an order. Otherwise, if you just did it yourself, and you don't have a will, and you just got a trust because on LegalZoom they were going to charge you too much for these supporting documents, and you didn't know everything else, you end up in probate.
Yeah, and I think that's the scary part. And I really hope that people do have that as a takeaway from this discussion, is that there are so many complexities and little sort of nuances to how you can really sort of make things go so much more smoothly. And I'm guilty of that myself too. Is like we have not put our house in the trust. We have an ADU that we're building that we're going to want to make sure that all of that is there. We do have other sort of assets, and we need to make sure that um, that it's just documented properly.
Sure.
So Leslie had another follow-up question. She does want to definitely get your information because she's been talking to some lenders. Man, a client she's going to recommend. So thank you. That's more of a thank you, Leslie. I appreciate
Sure.
that. Roger, also too, we really appreciate the feedback, and it's great that you're going to be like me, hopefully moving forward to get these things kind of in place for ourselves and for our beneficiaries. And I will put this in the meetup page, Roger, the content anywhere that I've posted this webinar. I will definitely put Thomas Christopher's information so you can reach out and email him too. So we still have a little bit more time, and I'm going to dive deep into one of my questions that
Sure.
I had as it pertains to an accessory dwelling unit. We're going to, and let's just say I know a guy. So I know a guy who has an ADU on their property, and the father-in-law is going to be moving into it. They will be selling their property out of the area to be closer to family. The father-in-law is 86 years old, doesn't have any chronic issues, is in good health, is ambulatory. Mentally, he's sharp as a tack. So this is a good time for him to be able to sort of process a transition and to move into the ADU, which, again, will be on the property of one of two children. So the sale of the house, let's say the sale of the house is in a trust. He will then put the house on the market, sell it. The trust will be the recipient of those funds. And then if he chose to, on his own discretion, wanted to pay, let's say, $50,000 towards the child to whom he is moving into the ADU. So there is several things are kind of happening there. One,
Sure.
there's as a beneficiary of the trust, they are getting an immediate benefit by receiving funds. And so what's the best way to kind of make sure that everything is documented to avoid any issues with the other sibling, the other child?
Right. Well, you're right. It's documenting things and just making things clear. Okay. You run into similar issues with a lot of blended family issues and things like that. So, number one, the $50,000 can be characterized as any number of things. It can be a one-time gift because they're so happy with your doing that, and you went to great expense to prepare this ADU on your property, and it can be meant to offset the expenses you had in purchasing or in preparing the ADU. It can be just a gift, okay, too. Now, if it exceeds that $16,000 level, he has to file a gift tax return for anything that exceeded that $16,000. It comes off of his lifetime gift exclusion, which is that $12.06 million right now. Okay. Now, people like to gift things now, and if they do it before the end of 2025, or if they change the law, you still have this inflated amount to gift that's going to be cut in half. So people can do that. So he'd only be using, a small amount of that 12.06 million.
Sure.
All right. So that's number one. It can be a gift. Number two, you have issues with regard to, you're having this parent come onto your property. They're not going to assisted living, which can be of tremendous expense and would spend down the parent's estate at a much higher rate than living on the property with you. Some people make arrangements where, the parent is going to pay a small rental amount on a monthly basis, or some kind of an agreed rental amount. It can be, it can be market value, or it can be some sweetheart deal that you're given to the person's parent because you just want to, that kind of thing. But that should be documented. And I'm not saying you have to have full blown, landlord tenant documents, but it should be documented with regard to the trust. You can also deal with it through amending the trust to reflect any kind of, if you want to reflect a gift to that child, okay, specifically, on the passing, where they would receive an amount to kind of equalize the value that they've given the parent ahead of time, or that they've already provided it. They're going to get paid after, from the estate after it's done. You can state, I'm just going to give them X amount, and it's, you can state what the reason is for it. You don't have to. Okay, it's not like some legal requirement. Children, although they typically inherit from parents, they're not legally required to. If you have a trust, you can give all your money to the German Shepherd Rescue, or the, whatever you're into, right? The old distiller's home, something like that, right?
Yes, I like that.
So it's appropriate for St. Patrick's Day.
Yes. So what they could do, Christopher, is in this person that I know's situation, the parent could say, I'm just giving X amount of dollars to this child. That is not a portion, does not affect the distribution of my estate on my passing.
Right.
So,
it's a one-time special gift.
Right.
And then if the trust says after, and quite often people make special gifts to individuals and charities. So monetary gifts. Okay. I want to give 5,000 to this person and 50,000 to this person and 100,000 to this person. Once those special gifts are made, then you have the residual beneficiaries of the trust, and that can be the children. Okay. And if it says the children, then whatever is left after those are made can be divided equally, or at whatever percentages you want to talk about. Okay. Sometimes you have estranged children that are disinherited. That means they expressly are excluded from receiving anything because they've either already received their distributive share and legal fees and all kinds of other stuff, or they just have not had a relationship with the person, and they're not going to receive anything. So, and you need to be very careful when you're doing that. Your documents need to state that you're doing it, and they should expressly disinherit somebody that you don't want to receive. Okay. But also, if you're giving gifts, you don't always have to put the reason why you're giving somebody a gift. It's your money. You can do whatever you want to with it. So there are provisions in the documents called the no contest clause. And they basically state that if anybody contests the trust and they're not successful, they get nothing. Right. They're treated as if they predeceased the creator of the trust without any kind of descendants. Okay. So they get nothing. And it also, in its modern form, lists what the challenges typically are. They are, you lacked capacity when you prepared it. There was undue influence or fraud or duress. There was forgery. There was some kind of misrepresentation, things like that. People can't just say, hey, that's not fair. I'm a kid and I deserve this. Well, if they do, they risk losing their entire share if they want to contest it.
And contesting is usually done in the courts.
It is. You have to be careful too when your parents have, needs, and you're almost like a caregiver for your parent, because caregivers are treated, gifts to caregivers are treated as suspect initially. There are numerous children who are caregivers for their parents and things like that. But, the court wants to protect people from, by the very nature that they're a caregiver, they can exert undue influence and things like that. So you have to be very careful under those circumstances to be very clear and tailor things. When I have seniors who are clients, and depending upon how they are, how old they are, my mom's, she's going to be coming up on 88, right? So if I have people that are seniors and I'm talking to them, I ask them, I said, hey, it can't hurt to get a letter from your doctor saying that you have the ability to manage your own affairs if there's any kind of question or you're engaging in these things.
So
and
you can looking forward to say, okay, let's say I have a sibling that is, I know they may say, mom or dad was not in the right frame of mind. You used undue influence and coercion to get them
Yeah.
to do this change. So
Yeah.
looking forward, you could say, let's just go to the doctor. Let's go have a
Yeah.
evaluation, or maybe it's their general, their general
Right.
doctor. And we can have some says, no, we have something that says they were in the good, right frame of mind.
Right. And the way things work now, they typically have their primary care physician, they have a neurologist, they have a cardiologist, they have all the ologists, right? So you can at least get 2 letters and just put them in your trust binder, just for, if it's at or about the time that you made these changes or updated things, depending upon how old, again, parents are, you may want to consider doing that kind of thing. It's just kind of for insurance and to avoid, because unfortunately it's our job to plan for the worst and hope for the best. And all the very high profile cases throughout the years of people fighting over estates are have involved these kind of things.
Before we're coming up towards the end of the hour, and I want to talk, are there best practices, and that may be premature to ask this question, because what I want to also know is, how does somebody who's interested in really kind of starting the process of, number one, maybe looking to see if their parent has everything in place, even though, oh, I have a trust. How do you have that conversation to say, well, can I look at it? Can we see that it's updated? Can we see that it's current? And then
Right.
number two, what would be the best practice for somebody such as myself,
Yeah.
or anybody who may be watching or listening to this? How do they really start the process? Because for me, it's just like,
It's overwhelming.
It is.
Yeah. So my story is this: I got involved in estate planning. My folks, I grew up in Burbank. My folks bought a place up in the hills of Burbank in the early 60s, had 4 kids. Dad, an SC grad, mom, a UCLA grad. Dad smoked cigars all his adult life. First semester of law school, he goes to a checkup, gets diagnosed with lung cancer, metastasized, and he passed away relatively quickly from then on. I had to jump into crisis mode for my folks and get an estate plan put together. So that's why I do estate planning, because I just felt it was a very important thing to do. And that's a very common story for people who have that kind of oh shit moment. Excuse my French, but that's what happens, right? So from a standpoint of existing trusts, sometimes just talking to their parents, seniors, a lot of people are intensely private and they don't like having their things known.
Correct. Yeah.
But if they don't have their documents in order, everything that they've struggled and saved could be at risk of going to the state or getting paid out in different probate matters, or to people they don't want to receive them. And if they're alive and they want to stay in their house and don't want to go into some facility, you have to make sure that the documents are in place to allow them to live independently. Okay, so that's it. Those are a couple of different ways of addressing the issue with seniors. We want to make sure that you can live as independently for as long as possible. We want to make sure that we can manage things and the court doesn't have to approve or become involved in any of it. And you have to make sure that they don't have an empty box, because they may have prepared their trust back when there was Cal Fed and Washington Mutual and all the other awesome banks that aren't around anymore. And even though it may have transitioned to Chase or whatever it is, they didn't transfer their assets into the trust, or they didn't, their account isn't in the name of the trust. So you have those kind of issues. So you can look at you can talk to them about independence. You can talk to them about making sure that their assets are titled to the trust. And then you can talk to them about the fact, since they live here in California, it's a very bureaucratic state and the laws change all the time. Right. If you haven't had your documents looked at for 5 or 10 years, you may want to have them looked at to see if they need to be updated, to make sure that what you want to have happen happens.
And because you talked about the binder, and I think that's a phenomenal resource and great recommendation, to have everything kind of in one place and have the tabs that kind of go through all of the stuff that's there. Within that, is that something where they would put all of their financial information, or keep, I don't want to say put bank statements in, but let's just say that they have an IRA or a 401k that's floating around from a company, and they didn't put it into any sort of an investment account. Like you went to, I forget where you can go with the federal government, you can find assets. It's like
Right.
misplaced little things, or you are beneficiary of X, Y, and Z. I remember I did that a couple of years ago, and I got like
Right.
$300 or $400 because somebody was holding a stock of Prudential.
Right.
And when somebody does pass, let's say that person, like my friend's father, is really meticulous with the stock, with his stock portfolio. He does have an IRA, so he had a lot of moving things. My question would be, how do you suggest somebody keep track of those things? Or
Well, I always recommend that you have a schedule of assets, even if it just lists, I have a bank and under bank accounts. Here's where I have my bank accounts, B of A and Wells. Okay. Here's where I have my investment securities and retirement accounts. I have Vanguard and Fidelity. You know, they can include the cover page to a, the January statement of that year or whatever. Sometimes they engage, a bookkeeper to just prepare a spreadsheet that they'll put in. Their tax people can do that. Sometimes, you can reverse engineer things through tax returns. But it's just at least having a very simple statement of what financial institutions you have where do you have accounts at which financial institutions, those kind of things.
Okay. And then as we kind of wrap up, last question is, where do people start with finding an estate, just to do their estate planning? Should they get on the California Bar's website? Should they Yelp it? Should they ask a friend?
So Yelp, Google, Nextdoor, these are all very helpful online services. Look at the reviews that people get, talk to friends. You can ask, if you have close enough friends, you can say, hey, have you guys done this? Who did you use? The highest compliment I can be paid is when my clients refer me to their family and friends and things like that. And when I have my clients make reviews. So that's a good way to do it. It could be as simple as, Googling, estate planning attorney, whatever city you're in. But you got to realize that the first several of those people are just big time advertisers, and you may just be another number to them. And they're going to charge you whatever they charge you because they do a ton of advertising and things like that. It may not have anything to do with their service that they provide. So,
because if you're at the top of the Google list, all of their analytics you could be paid to be there.
Yeah, and you shouldn't have to pay somebody for a consultation.
Okay, that's nice.
Now, if you're bringing them a trust that they're going to review and tell you what it does and whether it does what you think it does, you may pay a consultation fee to look at that. Okay, just depends. Everybody's different. But if you don't have an estate plan and you're meeting with somebody, you shouldn't be paying a consultation charge.
Got it. Great. Any parting thoughts?
I know it can be overwhelming, but estate planning is really important. It's one of those big things that you want to check off. If you own property, if you have kids, those kind of things. If you're married, if it's a second marriage, you got to be very clear and just get these things in place. It's from beginning to end. It doesn't have to be more than a 30 to 40 day process in certain circumstances. A lot of people just own a home and have some bank accounts and some retirement, that kind of stuff. That's very normal. But if you don't have any kind of a plan, California is going to have one for you, and you may not like it. Okay, so that's the idea. You just have to, make sure to plan. And even more importantly, if you're like, this trust stuff, it's mumbo jumbo, get power of attorney documents. You need to have documents where if you can't manage your affairs and you're not in charge of when you can make decisions or not, if you have a stroke or some other kind of significant health episode, make sure that you've listed people that you want to make decisions for you to make those decisions. So you're not just left at the mercy of the courts or the system, because they're overburdened, they're impersonal, and they have relatively little options for you.
Thank you. And I think that's it just kind of really kind of triggered when you said I believe at minimum, have somebody that you appoint them with the power of attorney, that if you are incapacitated, can kind of move things around. And I think that that's really critical.
Sure. Yep.
Thomas, thank you very much for your time today.
My pleasure.
I really am happy that we got the questions and the engagement that we did, because I know that there are folks out there with some very legitimate concerns, and I do hope that they're able to kind of move in that direction a little bit more easily and more comfortably. So I
Right.
want to thank you again, and to everybody who was here watching live. And if you're listening or watching it in the future, please feel free to reach out to Thomas. I will be putting his email information, contact information into the various social media platforms that we're on. Everybody have a great day.
All right. Thank you.
All right, bye-bye.
Have a great day.